of Downing. If you could pronounce that for me and help me.
My name is Tanawah. I am the civil rights litigator that Justin was just talking about in Washington, D.C. I need to provide a little bit of clarification so we can understand what was just said and how we move forward with this information that you guys are just given. So again, no state can create its own alternative legislation substitute that guarantees constitutional right or state violation of the Constitution. That would be obviously unconstitutional. So I have approximately 12,000 criminal affidavits on behalf of victims that have been charged by way of information, not indictment, in violation of the Constitution from right here in the state of Ohio. Many are from within your city here. Now, these affidavits, they identify two different crimes. The first crime is Title 18, subsection 242, which is deprivation of rights under color law. What that statute says is that any person who, under color of any state statute, ordinance, custom, or regulation, deprives any person of any rights secured by the Constitution commits that crime. The second crime is Title 18, subsection 241, which is conspiracy to deprive of rights. What that statute says is that when two or more persons conspire with the purpose of depriving any person of any rights secured by the Constitution commits that crime. Now, the laws of criminal conspiracy with regard to public officials, what that states is that any person who, having knowledge of any of the wrongs conspired to be done, and who have the power to prevent, or aid in the prevention of the commission of same, neglects or refuses to do so, may join in the action. So upon having been provided with this notice, letting you know that you guys are paying for law enforcement who are relying upon an inferior state statute to go out and perform an arrest in violation of the Constitution of the United States by charging by way of information, not by indictment. We would ask you to please, let's go ahead and work together to fix this. Because the alternative is that we will have to convert these criminal affidavits into criminal complaints. I don't want to go down that path, and you guys don't want me to go down that path either. All right? We've been in touch with the Director of the FBI, Mr. Patrick Tell, as well as also a regular member of the Senate Judicial Oversight Committee, Senator Kennedy. They both agree that when agents of the state, be it judges, prosecutors, law enforcement, when they fail to obey the constitutional obligations that they have and fulfill the federal law, that they are subject to arrest. So we don't want to head down that path. What we're here is not to get people into trouble, but rather to raise awareness on an issue so we can work together to get it fixed. Because we don't want to do this in a very, very messy way. Now, I know that you guys are going to go to your attorney since we're done. You're going to ask your attorney whether or not what I'm saying is true. And that attorney is going to point you to a case from 1884 from the United States Supreme Court called Hurtado versus California. And before you guys choose to rely upon that as your foundation, I must remind you that the Constitution of the United States of America is the foundation, not a judge-made ruling. The Supreme Court of the United States has no constituted authority to be able to alter or amend any of the provisions that guarantee the Constitution. That must be done by an authentic act in accordance with the Special Amendment Procedure of Article 5. Furthermore, judges cannot legislate. We know that because Clause 1, Article 1 says all legislative power is vested in Congress of the United States. So I implore you, all of you, to please, let's step up, discharge the duties of your office, fulfill the obligations and promises that you made to the people of the state of Ohio, and let's choose willfully to protect and preserve the Constitution of the United States before I have to take this to